appeal in the matter of Solitair and Nambiar.
Mr. Lewis.
My lady, yes. My ladies, my lord, I act on behalf of the appellant in this matter, strictly speaking, and subject to the preliminary point the court has raised by its directions of Friday afternoon. This is listed for the appeal of the appellant's final appeal against the decision of His Honour Judge Davies from the 17th of March 2021.
Yes, but you're going to deal with the preliminaries, as it were.
My lady, I am. I should add to that the court will note the respondent is not represented on this appeal. It became known.
The respondent went into voluntary liquidation in March of this year.
My lady, it did, and by virtue of being a voluntary liquidation, it's at least one less hurdle I have to overcome in terms of the moratorium, which would usually bite. Does not on this appeal or legal process. My lady, I filed at court on Monday.
Yep, we've got it.
time.
We've had it.
I'm grateful. I do seek permission to rely upon that document.
You have it.
According to the practice direction. My lady, the question posed by the court, the abuse point, as it were,
Yeah.
is whether, first and foremost, whether this is an abuse of the decision on the papers of Lord Justice Mayles, and if so, can and should this appeal to be proceed to the final hearing. My lady, the three points raised by my supplemental submissions of these. First and foremost, in my submission, it's not an abuse in the circumstance of this particular case. Secondly, if the court is against me on that point, and prima facie there is an abuse, first of all, as a matter of principle, the appellant cannot be stopped from asserting an unfettered statutory right to appeal, and or the court cannot be fettered in its jurisdiction, which is absolute under the administration of Justice Act 1960, under which this appeal is brought. If the court is against me on the principle, the court retains a discretion to strike out this appeal, and I would invite the court to do to the contrary and allow the appeal to proceed. And then, my lady, the fallback position of the appellant is that set out at the final part of my submissions, which is the court, in the particular unusual circumstance of this case, does retain residual power for a case of this kind in my submission to give effect to those statutory rights of appeal to effectively reopen the decision.
Mr. Lewis, we can take it, can we, that you've got full instructions to proceed with these submissions and to pursue the appeal despite the matters that the court has raised with you?
My lady, I do, and in fact I was anticipating my client being in attendance today, albeit unfortunately, given the travel issues in Manchester, he finds himself stuck in Manchester, which was nearly a situation which I found myself in yesterday.
So he's not in attendance, but you're confirming to my lady and to the court that you have full instructions to proceed on this basis.
My lady, yes, my instructing solicitor sits behind me. He was in contact with my client this morning.
Yeah.
Okay. And my lady, so far as necessary, the instructions are based upon the fact there is a suspended committal order, which is now, of course, expired. There is, of course, a final injunction order in place.
Yep.
And even insofar as any breach is found in respect to that final order, and indeed there's also a final order in the family proceedings, then any previous breach which has been found of contempt will be relevant to sentence on those future hearings. So this remains of importance to my client in those circumstances.
Yes, we understand why it might be of importance to your client, but we need to deal with this abuse problem.
Yes.
And just before you start to argue that it's not an abuse, you got the email, I hope, yesterday drawing your attention to the four authorities.
Lady, yes.
Yes,
I'm
all right.
Lady,
Just want to be clear about what the unfettered statutory right of appeal is a right, what the scope of that right is.
My lady, yes.
It is not a right to challenge a contempt finding. It is a right to challenge without leave a committal order.
My lady, that's right.
All right. If we just lay that groundwork,
yes.
you can then get on with your submissions.
I'm grateful. My lady, perhaps if I start on that point and the issue of principle to paragraph 4 of my supplemental skeleton argument.
Yes, well, that's why I asked for that email to go to you, because it looked as though you might not have understood that point.
Well, my lady, the Masri case, which is the last in the line of the authorities,
Yep.
there are 3 points which I wish to address the court on in that respect.
Yep.
My lady, so far as the statutory right is concerned and when and in what circumstance it arises, the court is quite clear it's when a committal order is made and when there is a risk to one's liberty is when the right arises. Lady, the court at paragraph 14 of the Masri case referred back to the practice note in the case of Barnet, Nambiar Council and Hurst, and the principle which the court has identified is set out there from paragraph 26 of the judgment in Hurst, that the appellate regime, there's distinction to be drawn between an order by which a party is committed to prison and any other order or decision made. What the court went on to acknowledge at paragraph 31 in Hurst is that it's not possible to legislate.
Sorry, I didn't have Hurst.
No, this is it's reading from Masri,
Yes,
but
and
you may not have
I haven't got Masri either. I've read it. Anyway, don't worry, we can rectify that.
It may quote verbatim from paragraph 14 of the judgment. The judgment refers back to paragraph 31 of the Hurst judgment, where it's acknowledged it is not possible to legislate in advance of every type of situation, but it's hoped that general principle will now be clear. The court moves on at paragraph 15 to cite.
Well, don't just read out Masri. Tell us what your point is in relation to Masri.
Well, Milady, the point that arises in this particular case, in the unusual circumstances, is this: at the very end.
Just hold on. In Masri, the companies had been found to have committed contempts.
Yes.
Okay. Before sanction was dealt with, the companies sought to appeal the contempt findings.
Yes.
That was the issue in Masri, and it is exactly what happened here. And the Court of Appeal said the right of appeal against the contempt finding is subject to the requirement to obtain permission, and the unrestricted right to appeal against a committal order is an unrestricted right of appeal against the sanction. The committal order is the sanction, it's the order sending the party to prison, whether it's immediate or suspended, and it does not, that exception in CPR 52.31A1 does not extend to the contempt finding.
Lady, the question that I pose to the court is what of those cases, such as the present case, where the court gives a party an indication that the custodial threshold has been passed. In Masri, the court at paragraph 16 based its decision on the comments of Lady Justice Hale, as she then was, which confirmed that the reason behind the court granting that right from the making of the committal order is because the court was described a sword hanging over the head, which put the individual's liberty at much greater risk than would otherwise be.
That was a suspended committal order, not an indication by a court that you might or might not go to prison.
Yes,
it was a suspended committal order.
Lady, in this case,
Yep.
the court below had given an indication to the defendant that unless and until evidence before the court of the circumstance in which this email came to be sent, the custodial threshold was met.
No.
That's not what he said.
Paragraph 132.
Yes.
Without anticipating the outcome of the further hearing, my provisional conclusion, etc., etc.
That's not unless and until.
Lady, in my submission to tantamount to the court.
No, I'm sorry.
My lady, the second point which I raised to the court.
Sorry, can I just raise another point?
Yes.
Appeals are against orders, not judgments. What we're concerned with is what was contained in the 27th of January order, which only dealt with the finding of contempt.
My lord, on the 7th of July, this court heard a full appeal in a like case of Hussein. In that case, and the judgment is in the...
Is that the business mortgage case?
My lady, it is.
Now, can I ask,
Well-
where does your information come from about what happened in that case?
My lord, the solicitor who was instructed by the appellant on that case.
Because I've also made some inquiries of the judges who heard that case.
Yes.
And what happened in that case, as I understand it, is that Mr. Justice Miles had a hearing in which he made a finding of contempt.
Yes.
He, at that hearing, extended the time for any appeal until after he had dealt with sanction. He imposed, after a further hearing, a sanction of 2 years, and thereafter the appeals came to the Court of Appeal. The Court of Appeal treated that there were many appeals, but they treated them as falling within 3 categories. First of all, there were a series of what could be characterised as interlocutory challenges to decisions to admit evidence, arguments the judge should have recused himself, and so on and so forth. And they treated those as one appeal,
Yes.
And they all required permission, and permission was refused. There were 2 other appeals, as it were, which were appeal against the finding of contempt and appeal against the sentence. So far as both of those were concerned, they dealt with them as not requiring permission to appeal. But that, of course, doesn't have any bearing on our case, because it meant that those were the challenge in that case to the contempt finding was made as it being part of the committal order once made.
My lord, the source of my opinion in the case comes from the solicitor. I know written reasons and a written judgment is awaited, but that's the extent of my knowledge of the case.
Well, we've just got the order. You gave us the order.
Yes, the order was received yesterday.
And we can tie up what my lord has just put to you.
Yes.
If we just very briefly look at two things. First of all, on page 306 of the additional authorities bundle that you provided us with, at 397, it's clear that Mr. Justice Miles extended time for appealing from the conclusion of the sanction hearing for 21 days. And that was for appealing both the contempt order and the sanction order. That's the first point.
Yes.
That's not what happened here. There was no extension of time sought. And indeed, you did appeal. But let's just park that for the moment. At 308 is the order that you're referring to, I think. In the order, the reference there, as I understand it, is to the interlocutory appeals that my lord mentioned.
Yes.
So those required permission to appeal. The first reference in paragraph 2 is to the committal sentence, and the second reference in paragraph 2 is to the contempt finding.
Yes.
Those were dealt with as of right, but as my lord says, the situation was different. There had been no attempt or fact of seeking to appeal the contempt finding in advance of the sanction finding.
My lady, the chronology, as I understand it, was in fact that the appeal was made immediately after the sanction findings.
Yes, exactly.
And then the sentence was later handed down. My lady, I should add to that point as far as this case is
So when
concerned.
you say the sentence was later handed down?
It was the appeal against the finding had been made before the sentence was handed down. Permission was sought in that case. So the judgment of the court where the findings were made, and then there was an adjournment for the sentencing hearing. The appeal was made at that point in time before the sentence.
Well, where's
permission was.
where's the
Where do we
material
find
to
that?
show that? Where do we find that?
My lady, I only know that from the information that's been provided.
What are we doing? Proceeding on PSA and who is the solicitor who's giving all this information?
Mr. Livingston, not of Jane, my lady of Jane's solicitors. The appeal 454 was issued prior to the sanctions hearing.
Well, where do we find that?
My lady, I don't have a judgment to advise the
Well,
court.
and where do we find that it was? How can we proceed on that basis?
My lady, the court requires the case to be stood down for the solicitor to send.
No, I'm not standing anything down. I'm just not going to. I don't see how the court can place any weight on what you've said in light of what we've understood.
My lady, the judgment of the court which was subject to appeal is in the bundle at...
Well, we've looked at paragraph 397, which extended time for appealing to 21 days after the order made at the sanction hearing. I just took you to that.
My lady, the basis of my submission, not like I'd readily accept, is from instructions given to me by those who instructed the appellant in that other appeal. And beyond...
Well, if you can't show it to us, I don't...
My lady,
I'm not
I have
very impressed
counsel's
by
skeleton argument from the appeal in which permission is sought, and it's the appeal referenced 454 the instructions that I were given.
Well, that was all. It was all dealt with together, as far as I can see.
And it wasn't
one
dealt with.
hearing-
Sorry
Oh.
to interrupt. It's clear from paragraph 2 of the order that appeal was not dealt with on a permission basis.
Yes.
My lady, precisely that's the point that I raise. I know not the reasons for that because no judgment has been delivered by this court. But I flagged with the court in my supplemental.
Well, it's possible to put it at its lowest that the reason was because the court took the view that on an appeal against a committal order, which was what it was hearing, it was possible to challenge the finding of contempt as well as the sanction as a matter of right. And if that were the position, this wouldn't help you at all.
My submissions do proceed on the basis that the right to make the appeals based upon the committal order which was made on the 17th of March, I should stress.
Well,
Yes.
you and nobody would have doubted the fact that you had an unfettered right to appeal against the 17th of March order.
Yes.
There may be an argument about whether in the course of that appeal you would have been entitled to challenge the underlying facts giving rise to the right to impose a punishment,
Yes.
penalty. What the problem that you have, however, Mr. Lewis, is that your client took the decision on the 11th of February to seek permission to appeal against the contempt findings. Now, there's no question that was, if that was the avenue you chose to go down, a perfectly proper way of proceeding, and there's no question that Lord Justice Mayles was right to deal with it as a permission application, because it was not a committal order, it was an order making findings of contempt.
Yes.
That appeal or application for permission to appeal has been finally disposed of. That is your difficulty, because as far as I can see, the grounds of appeal you now rely upon are identical in, I could only find a difference, irrelevant differences to those grounds of appeal that you raised in your 11th of February permission application, and are entirely directed at the contempt finding. I have seen nothing that seeks to challenge the sentence, whether the nature of the sentence or the length of the sentence. It is the underlying contempt finding you seek to challenge, and that has been finally disposed of. That's your problem.
Well, the question that the appellant poses to this court in light of the issue being raised, there are three important points in my submission. One, given that the appellant's right to an absolute appeal only came about in consequence of the 17th of March order, whether that right can be fettered by a paper determination refusing permission as a matter of principle, and likewise...
It's not fettering a right. It's about abusing the process of the court, Mr. Lewis.
My lady, the appellant's approach, that is what is described in my submissions as the procedural fait accompli, which is...
The procedural what?
Fait accompli. my lady, which is because the claim and the application were heard together, the appellant was always going to be faced with this difficulty.
Why?
Well, my lady, the court first handed down judgment on the 13th of January.
Yes.
At that stage, the appellant on the committal did not have the benefit of public funding, so the matter was adjourned off to the 21st of January 2021. I think it's the 27th of January 2021. On the 21st of January, he was granted public funding in respect of that hearing, returning for a sentencing hearing. Given the late issue of public funding, the court on that occasion gave the order which was provided on the 27th of January. My lady, it's not reflected by the order.
Sorry, so what?
My lady, it's not reflected by the order. The court can note from the chronology an extension of time is sought to appeal, but limited to the 10th of February, because the original date of the decision was the 13th of January. The court would only allow 28 days from the date of the original decision, which took us to the 10th of February.
Yeah.
The difficulty was faced by the appellant in this case, and this is the procedural unfairness complained of.
Sorry, I'm sorry to. Are you saying that on the 27th of January there was an extension of time granted which isn't reflected in the order?
My lord, it is insofar as if one looks at the order, the reason the order states the 10th of February.
Have we got the?
My lord, it's in a supplemental bundle at page 19. And the court will note from the...
Yes, thank you.
Sorry, page 19.
Yes, my lady.
Let's just...
Which is the provision providing extending the time for appeal.
At page 23, paragraph 20. 4 p.m. on the 10th of February, 21. That is 28 days.
Sorry,
Wrong.
which paragraph?
20.
Paragraph 20, my lady.
So is that what you sought? Did you seek an extension of time to the 10th of
Lady,
February?
the appellant, lead counsel who dealt with the trial,
Yes.
the day before, sought the
Yes.
extension.
That was the extension that was sought by counsel on behalf of Mr. Nambiar.
A longer extension was sought, but the court
Well,
reluctantly.
where's the evidence of that?
Lady, it's reflected by the order, which is,
Where's it reflected by the order?
lady, the recital of paragraph 13, at page 19, third recital. The decision was handed down on the 13th of January. The court calculated that as being the point of time for appeal. When the matter returned on the 27th of January, the appellant was concerned that 21 days took effect from the 13th of January. Therefore, the court took that date and extended up to a maximum of 28 days, the 10th of
Where do we get any material that shows us that your client's then representative sought a longer extension? For example, an extension to, let us say, 21 days from the date of the sanction hearing.
My lady, I was present at that hearing.
Yeah, that's recorded.
I appreciate it's not recorded on the order, that's an
So
extension.
what extension was sought?
My lady, as long a time as was possible in the circumstances.
No. Surely you must have asked. You can't make an extension
But
for
lady,
as long a time as possible. You,
Trial counsel simply sought an extension, and the court.
Well, what extension did he seek?
My lady, I know not.
well, you were
Simple
there.
recollection. I
Can't
was.
remember. Don't worry. If you
Can't
can't remember.
remember.
You can't remember.
But lady, the extension took us to the 10th of February, and the issue that the appellant was faced with on that occasion was this, and it's set out in my supplemental. This was an argument at page 6.
Your first go as an argument.
My supplemental, my lady.
Right.
Paragraph 6 is about the State of Norway case.
Lady, page 6.
Oh, page 6,
Yes.
I'm so sorry. Yep.
Uh,
Which paragraph?
Paragraph D,
Yep.
Roman numerals 1 to 4. I raised the point with the court. Had the appellant not apply for permission against the finding on that occasion. The difficulty he faced, if he simply waited until sentence was handed down, in the event a committal order was not made then on the 17th of March, the appellant would be some 2 months out of time facing the uphill task of an application for relief.
Well, there were two things that could have happened, aren't there? One is that you could have sought an extension of time in the terms in which Mr. Justice Miles granted it in the business mortgages case, that is to say, an extension of time running from when sanction occurred. The other is having issued an appeal notice in relation to the contempt finding, you could have invited the court not to deal with it until after sanction, so that if the sanction involved a committal order,
Yes.
then it could have been pursued as of right. If it didn't and you still wanted to challenge the finding of contempt, it could be pursued by way of an application for permission to appeal. Is it fair to say those were two options which were open to you?
My lord, they were, but the factor which takes this case away from the issue in the Hussein case, the fact that there was also findings on the claim which were linked to the application, which the appellant sought to attack by appeal on the claim. So the issue as to whether...
Well, they could have been dealt with entirely separately.
Yeah.
You could have either had a separate appeal notice or could have said
There were
in the appeal notice that was issued, please deal with that, but don't deal for the time being with the appeal in relation to the finding of contempt.
My lord, that's dealt with on page 7.
Well, first, do you accept what my lord has put to you, that those were options open to you?
My lady, those options were closed by the fact there was an appeal on the claim, and we would have still been met with the same abuse problem. The appeal on the claim was to attack the findings of the judge. The same findings were made both on the claim and the application. So presupposing we make that application to stay the appeal on the committal, the claim is dealt with on the papers by Lord Justice Males. He dismisses the attack against the findings on the claim.
But you could have made the same argument in relation to the appeal notice in relation to the claim.
Lady,
Please, court, do not deal with these. Otherwise, there is a risk of being closed off from appealing and an abuse possibility. Wait until the sanction hearing. And then following the sanction hearing, as my lord has put to you, you either appeal as of right the committal order or you resurrect your permission to appeal applications. Do you accept that was an option open to your client?
Well, on its face, yes, but in the circumstance of this case, the option was closed by the claim. Because,
So you don't accept it?
well, my lady, if a request was sought, it would still, in my submission, impact upon the appellant's absolute right following the committal order. The difficulty the appellant had on the claim, of course, there was significant monetary relief granted on the claim.
So what?
There was a significant cost order made on the claim.
So what?
My lady, any application for a stay of that appeal would, by its very nature, seek a stay of the relief given until determination of appeal. The difficulty we had would have been that we were on an unknown date being sentenced. We come back 2 months later for sentence. So if the court then rejected that application on the claim, which in my submission would have been appropriate for the court, because why should we stay an appeal on a claim where there is final relief granted? We would still be met with the same potential problem of an abuse on the appeal on the committal.
You say an unknown date. I think the 27th January order fixed
Fixed,
the sentencing hearing for the 17th of March.
Yeah.
Paragraph 13.
My lord,
Is that right?
the order was certainly issued in 20, my lord, yes.
Thank you.
But it still comes back, in my submission, to the fundamental difficulty the appellant was faced with procedurally, because the claim and the appeal were heard together below. So, for example, any impact upon any application to stay my rights of appeal on the application to commit is impacted upon any application to stay on the claim, that appeal, and was naturally impacted. And this goes to ground 3 of the appeal, which is the procedural unfairness. I readily accept the claim is dealt with separately. We would not, like in Hussein, we would not find ourselves in that position. But either we invite the court to deal with the two together on appeal, in which case our appeal rights against the committal are affected by the fact there's a claim. We're asking not only to stay the appeal on the committal, but also the appeal on the claim.
But my latest question to you was, would it have been open to you to ask the court not to deal with the appeal on the claim until after sanction? And I haven't understood your reason for saying that wouldn't have been open to you.
My Lord, it would, but it would have been tantamount to an application for relief for an extension of time on the appeal.
Yes. And why couldn't you have asked for that?
Well, my Lord, we could, but that should not fetter in my submission the appellant's absolute right of appeal that later came.
So wait, a moment ago, I think I recorded you were saying, in answer to my lady's first question, that it was an option that was open to you, but it was an option that was closed off by the fact that there was an appeal by the claim. Are
Yes.
you now accepting that it wasn't an option that was closed off because it was open to you to ask for an extension of time in relation to the appeal?
My Lord,
against the
it was certainly open. My submission is that in the circumstance of this case, because the claim was dealt with together procedurally.
This is your second ground of appeal, is it? So on the substantive appeal, you say that because you challenge and there are aspects of your second ground of appeal that have nothing to do with the civil findings, because you complain about the wrong standard of proof being addressed, which is a point that's unrelated. But you say that your second ground of appeal on the contempt against the contempt finding overlaps with the civil findings on the claim.
Yes.
In relation to the email of the 19th of December.
Yes. So we were always going to be met with that fundamental problem. I accept it's a different kind of abuse, but we were always going to be met with that problem because of the claim. You're either going to be met with a problem of having to apply for relief on 2 appeal applications, even insofar as the court then granted one and not the other and heard the claim. We would still be met with the same abuse point, which would be, well, you've attacked the findings on the claim on ground 2 of your appeal against the claim, which is linked to ground 2 of the appeal.
I mean, I can see it's all very complicated, but the bottom line is, it's procedurally complex, but the bottom line is, that as my lord and my lady have said, this could all have been wrapped up. I mean, nobody said before the judge below the reason why we need an extension of time of 21 days after the sanction hearing, because there are all these. This is what could happen.
Yes.
And that was an option, and
Yes.
it wasn't taken. And I'm not necessarily criticising anybody, but that would have been on. If you're right about the overlap
Yes.
point, then that would have been, at the moment, as far as I can see it, the solution and probably the only solution.
And Milady, I suppose going back to the question for this court to decide off on a preliminary basis, does that then stop the appellant from exercising his full rights, which only came about?
Am I right that nobody, and again, I know that you've just been instructed, you were there remotely, it's simply on the sentencing aspect, according
Yes.
to the order, but nobody, am I right in thinking that none of this was thought through as such expressly before the judge below on the application for an extension of time?
Milady, it was not, albeit at the return hearing for the sentencing hearing, the judge below, the Appellants Notice in accordance with the practice direction had to be lodged at the court below. So the court below was certainly aware that there was an appeal had been made.
Yeah, and I'm focusing on the extension of time that was sought, its basis. And it was not, nobody was thinking this through at the time.
Milady, no.
No, thank you.
And that comes back to the question of this court has the jurisdiction on the appeal from the 17th of March.
Yes.
Under section 13.3
Yes.
of the Act.
Your client has an unfettered right to appeal
Yes.
against his sentence.
Against the order, yes.
Yes, the order is a sentence
Yes.
order. It's
Yes.
a committal to prison. That's the whole point.
Yes.
So what is your what is the appeal against the sentence?
Well, my lady, the appeal is against the order still for the procedural unfair. So ground 3 of the substantive appeal
Yes.
continues through and is material.
But what is the appeal against the committal order?
My lady, the committal order, the proceedings below were procedurally unfair, and in fact, the unfairness...
The sentence hearing was procedurally unfair, or the contempt hearing was procedurally unfair?
The proceedings below as a whole for the purposes of the appeal. So when the court returned to make the order on the 17th of March, paragraph 17 of the court's judgment, perhaps I can take the court to that.
Well, is your submission simply this, that if you've done nothing before, then you have an absolute right to appeal against the committal order? That involves an ability to challenge both the finding of contempt and sentence, and that's what you're seeking to do now. And that's an absolute right you have without permission under the Act. Is it as simple as that?
My lord, it is, and in the circumstance of this case, even if prima facie there is an abuse, it doesn't necessarily follow, in my submission, in the peculiar circumstance we find ourselves in, that the appellant is constrained by the fact that being a paid position.
The inevitable consequence of success on your substantive appeal is that Lord Justice Mayles was completely wrong.
But, my lady, there are two aspects of the paid decision, which of course it's not a criticism of the court, it's naturally a decision on the papers. The decision itself was applying a different test, a test which...
Could you answer the question?
My lady, no, because there are certain aspects of the substantive appeal which are not dealt with by the written decision of Lord Justice Mayles. And the one key one, which is at the heart of this appeal on the procedural unfairness point, is this. The main thrust of the argument on the substantive appeal is that the proceedings below were procedurally unfair because the court combined a substantive claim and a committal application as one. Mm-hmm. And I accept that in certain circumstances that in and of itself is not sufficient. But that order, which for the benefit of the court can find...
An order that was
Page
made with the consent of both sides.
No, it was not. It was not. It's not a consent order. It was not made with the consent of both sides.
Well, as I read it, His Honour Judge Davis says that both sides agreed to that way of dealing with it. Let me just find where he said that.
Whilst my lady does that, I mean, Lord Justice Mayles dealt head-on with procedural unfairness.
Yes, I mean that was a point that was before
Yes.
Justice Mayles, wasn't it? It's not new on your grounds here.
Well, my lord, the point not before Lord Justice Mayles on the procedural unfairness point is paragraph 17 of the judgment on sentencing, which has to be read alongside the prior judgment.
Right, just bear with me. Paragraph 17 of the sentence. Sorry, Ingrid, I know.
No. 17 of, is this 17 of the sentence?
Page 80 of the core bundle,
Yes.
paragraph 17.
Page.
So this...
Sorry, Joe, hold on. Page. Sorry.
Page 80, my lady, paragraph
80.
17.
Page 8.
80.
So paragraph 17.
Yes.
Right.
And what the judge, in the second judgment, which was not before Lord Justice Mayles, and this is part of the procedural unfairness argument which the appellant wishes to advance on the substantive appeal, of course, only comes about following this judgment and the order being made. The judge finds, I'm reading from the third
Well, this
sentence,
is the new evidence point. This is the new evidence point.
Yes.
Well, how can that possibly help you in terms of timing? Because the short point was, this was for reason. Well, your client didn't produce this new evidence at the right time.
The procedural unfairness points that on a committal application, the court combined both the claim and the committal application. It's page 18 of the supplemental bundle is the order. It's not an order made by consent. The
I
court,
understand.
the court debarred the defendant from relying upon any further evidence in those proceedings, save other than the evidence that had been given to date.
But there's no complaint in your grounds of appeal against that debarring order, is there?
My lady, there is. It's in ground 3 of the appeal.
That's just all right. So is it direct? That's got nothing to do with combining the claims. That's a discrete order made because your client had failed to comply with lots of procedural orders, as I remember. So let's look at your procedural errors and irregularities. Which paragraph do you complain about the debarring order, please?
Lady, it's page 41 of the core bundle. It's ground 3, subparagraph C.
41 of the core bundle.
The court, and this procedural unfairness followed through to the judgment handed down on the 17th of March. The court found and drew adverse inferences from the appellant's want of disclosure. So going back to paragraph 17 of the judgment, the judge found it was of his own making.
Can I just rewind for a moment? The point that my Lady Justice Carr put to you that sparked this element of the discussion was that if we were to accept your substantive grounds, then Lord Justice Mayles must have been wrong. You initially said that that wasn't so because of the point about the procedural unfairness not having been before him. That it was pointed out to you that the procedural unfairness point was squarely before him, but you said there's an additional point.
Yes.
Which wasn't before him, which is that which is dealt with at paragraph 17 of the sanctions judgment.
Yes.
But that was
Now, just pausing there, what the judge dealt with at paragraph 17 of the sanctions judgment was a question that went to mitigation, that is to say, what sanction should be involved, wasn't it?
Yes.
And you're not, on this appeal, seeking to make any challenge to the sanction as such. The challenge to the sanction is entirely dependent on the challenge to the finding of contempt. So far as the argument which would be before us, if you were allowed to develop it, and the argument which was before Lord Justice Mayles is concerned, what the judge said at paragraph 17 of the sentencing hearing is entirely irrelevant, isn't it?
My Lord, in my respect for submission, no. The reason for that being, my Lord, the two stand and fall together. The court's suggesting, well, that aspect of the judgment of paragraph 17 is relevant to mitigation. It was that aspect of the court's judgment which was the difference between either a committal order being made, i.e. a suspended order for the purposes of the authority.
But you're not complaining about the committal order.
This material wasn't treated by the judge as relevant to his finding on committal. He said, I didn't have it then.
Yeah.
If you'd wanted to rely on it then, you could have done. My reasoning for having found that there was a contempt stand.
Yes.
I do, however, have to look at this to see whether it makes any difference to mitigation and therefore sanction, which is what I'm now concerned with, and for the reasons he gives, he found it didn't. What was before Lord Justice Mayles on his permission application, and what you want to put substantively before this court on your challenge to the finding of contempt, is unaffected by that new evidence, isn't it?
My Lord, no, Lord Justice Mayles' decision does not address this issue of can the court be satisfied? There's no real risk of injustice to a defendant in committal proceedings who is debarred from giving evidence in these proceedings. It goes back to my argument on the abuse point. Given the nature of...
I thought you were focused on paragraph 17 of His Honour Judge Davies's judgment. That was the answer you gave to my lord and my lady about why, if this case goes ahead with your substantive appeal and it's accepted, Lord Justice Mayles wouldn't be wrong because it would be a whole different picture.
My lady, Lord Justice Mayles didn't deal in my submission expressly within the written reasons with that point.
But
Well,
he,
of
but he
course it
didn't
is.
need to deal with the
Hadn't been
paragraph
raised.
17 point, because the paragraph 17 point relates to mitigation.
Yes.
And you are not arguing, are you, that the sentence should not have been a sentence of suspended imprisonment, or that the length of the sentence was wrong?
Lady, I'm arguing that the procedures adopted below, the procedural irregularities which led to the making of the order,
Yes.
are such that the committal order should be set aside.
Yes. You are saying that the conviction was wrongly obtained.
Yes.
It was unfair.
Yes.
That's nothing to do with mitigation, is it?
Lady, no.
Right.
Lady, perhaps if I can address the court on the issue of the principle of abuse, which is dealt with in my supplemental skeleton argument at page 3, paragraph 7. Lady, I set out 4 principles which are lifted from the commentary at 3.4 of the White Book. It doesn't necessarily follow in my submission that if this court finds that this appeal is an abusive attack upon
I'm so sorry, Mr. Lewis. It's my fault. Where are you looking? In
page 3, paragraph 7 of the supplemental,
Yeah.
my lady. The first point is if the court finds that this appeal is potentially abusive and attack upon Lord Justice Mayors, it doesn't necessarily follow that the court must strike out,
Not if it's potentially. But
This
if it's,
is-
what about if it's an actually?
or if it's actually, if it's
And
if it's
just where's the
abusive.
Where do
authority
you
for that proposition? Please. Which bit of the notes? Where do we see that?
My lady, the paragraph 3.4.5 in the White Book,
Thank you.
citing the House of Lords in Johnson and Gore-Wood. Whether the litigation of decided issues and abuse depends on all of the circumstances, and a broad merits-based judgment should be adopted in respect of the same. And the
Yes, well, that goes to whether it is or isn't an abuse.
Yeah.
I think the submission you're on at the moment is if it is an abuse, the court can ignore it. Which authority establishes that?
that is the my lord, the commentary at 3.4.10 of the
This is your Smith and Linskill's authority, is it?
my lady, no, this is the citing in the commentary at Hunter. The court
4.10.
But this is about the rule. This is, again, as my lord says, the rule in Hunter, this is the paragraph, third paragraph, is not an inflexible rule to be applied to all cases which might arguably be said to fall within it. Although the mounting of an attack upon an earlier decision might be an abusive process, not necessarily so, we're asking ourselves, assume that this is abusive.
yes.
And my lord says, show us the authority which says, if abusive, you can still proceed with it.
Well, my lady, as part of the
If your point is better expressed, I don't mean that impolitely, as saying, in deciding whether or not something is an abuse, you take a flexible, broad, merits-based approach, and taking that approach, it's not abusive, that's one thing.
yes.
But if you're saying it's abusive, but you can still carry on with it, that's another. And I don't think that there's any authority for the latter proposition.
My lady, it is the former,
Right.
and
So assume it's not, it's, right,
So if it's abusive, then
That's
you
it.
accept that's it. The court can't just ignore it. You're saying in order to determine whether it's abusive,
Yeah.
you can have regard to all the circumstances and, as my lady said, the broad merits.
my lady, yes.
Right. Okay.
And
So
my
where do
lady,
we go
as
next?
part of that, the question the court is to ask is whether it's manifestly unfair to the other parties of the proceedings for obvious reasons, whether they should be dragged through the litigation again. And in my submission, the answer to that is plainly no. This is a respondent who has not nothing to gain.
The problem here seems to me to be more fundamental. It's an affront to the court process.
Yeah.
It's not. This is not one of those. You're quite right. There's a whole series of cases dealing with, harassing finality of litigation and all the rest. We're not really looking at that. We're looking at. I mean, just put it this way: what does it look like to the outside world to have two opposing, conflicting decisions from the same court on the same material within a year, with no change in the law?
Milady, the difference in this case, of course, what's at stake for the...
No. What is your answer? How does it look? It looks fine, does it? Do you say?
Milady, it's not that needs to be balanced, of course, as part of the administration of justice. On the one hand, the finality and the reliance upon court decisions. On the other side is the right of this appellant and other litigants who find themselves in the same position as this appellant, and the unenvious position in my submission that the appellant found himself in following the hearing of both the claim and the application together, and his appellate rights, which were plainly impacted. Come what may, even on the court's analysis of my submission, the appellate rights, which he has an absolute right, were plainly affected by the fact that the claim had been heard alongside the application. It's not uncommon in my submission for courts below to deal with cases as a practitioner and deals with housing cases, for possession orders to be made alongside committal orders, the court to adjourn sentence for pre-sentence report and the like. And the appellant in those circumstances, because the two cases are heard together below, are in the unenvious position in which this appellant found himself.
So it's a point of real practical significance, you say?
Milady, as to whether this court, an absolute statutory right of appeal can be extinguished by a paper determination of refusal of permission, is an important point in my submission, because
I don't see the fact that it's on paper is immaterial. It's final.
And also,
and it's a lesser standard. Sorry, it's a lesser standard. All you have to establish to get permission to appeal is that you've got some arguable points, and you didn't get over that hurdle.
My lord, the three factors which I highlighted and I discussed in an argument, which were material since Lord Justice Mayles considered the decision. One, the absolute right then arose following the order on the 17th of March, and what impact that has upon the right when we no longer require permission to appeal. Secondly, and I've addressed the court, the point is the judgment in my submission on the sentence. The procedural unfairness is reflected again by this want of evidence, or the appellant was maintaining the purpose of sentence, whether or not a committal order should be made, a suspended sentence should be passed, was maintaining the email was not sent, and I really accept he didn't help himself in doing that, but the reality was that was his case and was always going to be his case. The problem he had, when looking back throughout the entirety of the proceedings below, stands and falls with the order in the supplemental bundle at page 18, which was the court consolidated a committal application and a substantive claim. And pausing for a moment, importantly, when the court did consolidate those proceedings, the appellant was, for the rules of the court, a litigant in person. He had no solicitors, so he was conducting the litigation. He had direct access counsel for hearings, and my lord, you'll note at the final hearing, in fact, at which I was not present, direct access counsel was only able to represent for part, so he was partly a litigant in person conducting the committal application. But the procedural unfairness followed the right way through to the final order, which Lord Justice Mayles did not have, which was when the court consolidated those two matters, the court then debarring the appellant, the would-be contender, with providing any further evidence.
Lord Justice Mayles dealt with that point, didn't he? As I recollect, he said he was represented at the December hearing, and he could then have objected to the two matters being heard together.
My lord, the problem in this case is that the actual unfairness which resulted didn't result until the committal order was made.
No, I mean, again, it's actual unfairness could only be, if there at all, only in terms of the resulting in an excessive sentence, and there's no complaint about that.
Well, the presumptive fairness in this case is the appellant was unable to provide evidence by an order of this court to defend an allegation of contempt, should he wish to do so, because he was debarred from putting any further evidence beyond, he was confined to the evidence he'd already filed and served at a point in time. That, in my submission, is the heart of ground 3 in procedural unfairness. My Lord, the third point in my submission, which is a material point beyond Lord Justice Mayall's paper decision, is this court, in these purposes of the like appeal in Hussein, acknowledging that this particular point as to whether, so Lord Justice Mayall's dismissed ground 1 on the point, and this was not before the court, before Lord Justice Mayall's, he dismissed the point as to whether the non-personal service of injunction at the time of the breach, and found that the court could have dispensed with service and also would have dispensed with service. The issue of could, in my submission, is a pure point of law, and it's a pure point of law which this court in the Hussein case decided against your client's interests. My Lord,
because they dismissed the appeal for reasons to be given. That point was taken.
My Lord,
so they must have taken the view that argument was a bad one.
My Lord, yes, but did also certify that the point itself is a point of law of general public importance.
So what?
So, my Lord...
Yes, we know that. They certified the point, but they didn't give permission, did they?
My Lady, they did not.
No.
So there's no permission to argue it at the moment?
My Lady, there's certainly subject to funding and application permission that will be made, as I understand it, on that particular point.
So Lord Justice Mayall's on paper determined that the point was a bad one, i.e. that there was jurisdiction to dispense with service retrospectively, and the recent decision of the Court of Appeal, although we don't have the reasons yet, is going to confirm that.
My Lord, on the point of whether there is a compelling reason for this full appeal to be heard, if the court, for example, does not hear the full appeal in this case, and this appellant does not have the right to advance to this court as to why, or to advance in any further court as to why the court would not have had the power, that is not a right. That's a right my client has.
So there's a compelling reason because the law might change.
My Lord, yes. Or certainly the appellant in this case, raising the same point which has been certified, would wish to pursue the point. It is an important point. The court has had 2 cases in the space of a handful of weeks raising the same point. I addressed the court on the nature of Lord Justice Mayall's decision at page 4 of the supplemental skeleton argument, which, when the court takes the rules, merits, based approach of this particular case,
Yep.
the fact it was a paper decision.
Why does that matter?
Well, lady, it was a case where the appellant had no right, subject to jurisdiction afforded by 5230, to challenge that decision.
Why does that matter?
That is one factor in my submission the court can and should take into account as to whether this appeal is abusive. The appellant, who has an absolute right of appeal, was not able to address the court in oral submissions in the adversarial process in the usual way as to why the decision below was wrong. The nature of the decision...
He had the opportunity to put in a very lengthy skeleton argument making those submissions.
Well, he did, but
it was considered carefully and fully by Lord Justice Mayall's in the way in which all appeals, save for committal order appeals, are dealt with at a permission stage. As my Lord has said, the standard that he had to overcome to obtain an oral hearing or a full hearing of that appeal, was a lower standard. He had to show arguable with a real prospect of success.
Yes.
Well, he didn't meet that. Lord Justice Mayles has given detailed reasons why. Why hasn't he had his full opportunity, not only to challenge the contempt allegations at a trial at which he was represented, able to challenge the evidence and cross-examine, and on appeal, albeit he didn't get over the first hurdle?
My lady, the full opportunity only arose on after the 17th of March. And again, going back to the...
What do you mean? It didn't only arise. You exercised a right of appeal on the 11th of February. He's had that right of appeal
But my lady,
dealt with in the proper and appropriate way.
My lady, when the right was exercised on the 11th of February, it was subject to that caveat of permission. On the 17th of March, when the full rights accrued, it is not subject to that caveat. And the difficulty the appellant, which I've addressed the court on, found himself in the interim, still, well, an application for relief could have been made, and that would have involved an application for relief on the claim as well.
Yes, well, we've gone
Yes.
round that. We may take a different view from you, but there it is. We've heard what you say. So you say the reason why he hasn't had a full opportunity is simply because he had to obtain permission.
My lady, yes, and as part of that, because the claim, importantly, because the appellant instructed trial counsel to appeal against the claim, his rights were always going to be affected. He was...
Well, we've put to you the possibility of saying to the judge on the 27th of January, there is a problem unless you extend time for permission to appeal, for me to seek permission to appeal, both in relation to the claim and in relation to the contempt findings, until after the sanction hearing. And no doubt, had you done that, the judge would have done exactly what Mr. Justice Miles appears to have done in the business mortgage case that you rely on, namely extend time for appealing everything for 21 days from the sanction order.
Lady,
that would have been a way of resolving all these difficulties.
It would, but the difficulty the appellant would have to get over to have his full rights exercised in those circumstances, the problem still remains of the claim. He would need the two. He would need relief on two applications. And
no, he needs an extension of time for both the appeal against the claim, the appeal against the contempt findings, until 21 days from the sanction finding.
And, my lady, that application is an application for relief.
Why?
It's not. It's an extension of time.
Extension of time.
Because
the order, the extension of time order was simply an order. Yes, so time was extended.
It's in fact, my lady, the rules, in fact, provide that any application should have come to this court for an extension, as opposed to the judge below. And what the
Are you saying the judge below didn't have power to make that order?
Lady, on reflection on the rules, it's the appellate court which grants the extension according to...
So you're saying Mr. Justice Miles in the business management case had no power to extend the time for appeal until 21 days after sanction? I find that a very surprising proposition.
I think it's wrong. I think the court below has power to extend for up to 56 days, but no more. I think, but I might have misremembered that.
You could be right, Mr. Lewis, that it's preferable. But I'm up to... Let's just have a look at 52.
I believe it's 5214.
Yes, 14.
5214, is it?
No.
4. Which rule is it, Mr. Lewis? 5215. Parties may not agree to extend any date or time set by an order of the appeal court or the lower court. Oh, that's to vary the time limit.
That's to vary the time. Which is the one we're talking about? Because it's 21 days from the date of the order.
Yeah.
Whatever it is.
Yeah. Well, that suggests that the lower court can make the order that Mr. Justice Miles made.
Look at 52.12, subparagraph 2.
Yeah.
Page 1895. Must file within such period as may be directed by the lower court. or 21 days, and then subject to the
Yes.
power to vary. So the lower court has got...
The appellant is asking the court to exercise an indulgence, and the complaint of the appellant in this...
It's not relief from sanctions, it's a variation of time.
It made an advance, my lady, yes.
Well, you were discussing it on the 27th of January. You said yourself, your predecessor, Mr. Nambiar's trial counsel, asked for an extension to the 10th of February. He could have said, couldn't he, we've already gone through this, 21 days for both appeals from the date of the sanction order, so that we don't get into the procedural difficulties that will otherwise be caused.
Lady, yes, it was not a procedural difficulty which was allied to the parties or the court at that time.
Well, that may be right, but that's not the court's fault.
Lady, the nature of Lord Justice Mayall's decision, I identified the court, the Linskills case, which the court referred to a moment ago.
But that's against you, Mr. Lewis.
My lord, on the principle, in my submission, what the Linskills case identifies is the court should look at the nature of the decision.
Is the what nature?
The nature of the decision that's allegedly being the subject of a collateral attack, and the nature of the decision of Lord Justice Mayall's being a paper determination as opposed to a full appeal hearing or an oral appeal hearing, in my submission, is relevant to, in the circumstance of this case.
Which bit of Smith and Linskills do you rely on as support for your position, please?
Lady, it's 419 of the updated authorities bundle.
Yep.
Lady, the court identifies, in terms of the principle, of the need for the intending party to challenge the decision, to have had a full opportunity of contesting the decision against him. So in this case, the appellant having the full opportunity to contest Lord Justice Mayall's decision in terms...
You've misread it. He had the full opportunity before His Honour Judge Davies, with the benefit of counsel throughout the proceedings, having pleaded not guilty to the contempt allegation, and effectively I'm reading from that substantive paragraph, having attended the trial and been able to give instructions to counsel on cross-examination, etc., etc. He then pursued an application for leave to appeal. The only thing he didn't have is the ability to renew that application to the full court, because the rules in crime are different from the rules in civil, but he had what the rules offer any appellant in his situation. Why was that not a full opportunity to contest the contempt charge?
Lady, when one's looking at the full opportunity of contesting the contempt charge, in my submission for the abuse point, it's limited to looking at the full opportunity to contest Lord Justice Mayall's decision.
Well, that's not what this case says. Lord Bingham...
Your decision's muddled up. You just need to read it carefully. So when it's talking about all the things that happened below, it's talking about... So the equivalent of the full opportunity stuff here is the equivalent of the full opportunity to contest the contempt charge.
I think that's what I've put to you, Mr. Lewis.
Lady, this is a case
I was effectively analogizing from the decision of Lord Justice, I think it is Bingham?
Lady, yes.
Yeah. Well, if you look at the line starting, we cannot think that Lord Diplock would have regarded Mr. Smith as lacking a full opportunity. You see that?
Lady, yes.
Right. It's of contesting the Crown Court decision against him. That equates to, doesn't it, the contempt allegation in front of Mr. Justice Davies at trial, leading to the 27th of January order.
Lady, no, that's looking at the early decision being attacked in this case is the Crown Court findings on a subsequent case.
It's the conviction.
Yes.
Yes, here you are trying to challenge the conviction, the contempt finding.
But Lady,
you haven't for a minute challenged the sentence.
The alleged abuse in this case is against Lord Justice Mayall's decision.
The abuse, Sorry, go on. No, go on.
Even assuming that you were right in saying the relevant decision that you hadn't had a right to challenge was Lord Justice Mayall's decision on paper, that has nothing to do with whether it's a permission application or a substantive application. If you were allowed to argue your grounds and we made a decision, you wouldn't have a right to challenge it.
Well, but the right of the appellant in this case, and this is the material point, only arose on the 17th of March, and because of the procedural history of the case and the claim and the application for committal being dealt with as one, the appellate's absolute right to appeal on the 17th of March were fundamentally affected from the moment the judgment dealt with both parts.
Well, if that's right, what possessed the legal team to put in an 11th of February notice of appeal? If the right only arose on the 17th of March, why not wait till the 17th of March?
Well, because come the 17th of March, it would be 2 months out of time. If the permission was sought on the 11th of March on the 11th of February to extend time, his rights were affected naturally by the fact he would need both the claim and the application to be stayed.
Yeah, we're going round and round.
Lady.
Well, so where does Smith and Linskills help us? You say because it shows the appeal to Lord Justice Mayall's wasn't a full appeal.
But yes, the nature of the decision and the...
Because it's on paper.
Yes.
The fact it's on paper means he didn't have and he didn't get an oral hearing.
And the fact the decision being made by the court on the paper was one for permission, which is a caveat which the appellant, as of the 17th of March, is not subject to.
And not only on paper, but on paper in circumstances where a fortiori the judge would have decided that the application could be disposed of without a hearing.
Well,
Could
yes.
be disposed of fairly without a hearing.
Because if the judge had thought it wasn't possible to dispose of the application without a hearing, he would have called for an oral hearing. That's a power all single Lord Justices and Lady Justices have.
It's an obligation,
Yes.
isn't it?
Yes?
Yes, ma'am.
Right.
Lady, so to conclude on the points with which I start on the preliminary issue, is, in all of the circumstances of this case, this appeal abusive of the decision of Lord Justice Mayall's? The appellant maintains, respectfully, it is not, and the appellant identifies to the court the reasons set out in the supplemental submissions. One, the circumstance of this case, if that finding is to be made, would deprive the appellant of a full hearing of his appeal and a substantive consideration. Two, it would deprive this court of the statutory jurisdiction under section 13(3) of the 1960 Act, which is a jurisdiction which the appellant can ask the court to exercise.
I'm afraid I don't understand that submission. All cases of abuse are cases where there is an entitlement under the letter of the law or the letter of jurisdiction to proceed, but proceeding is abusive and therefore the litigant is prevented from doing so. Every case of abuse deprives the court of the jurisdiction it would otherwise have, doesn't it?
My Lord,
almost every case, anyway.
My Lord, where the jurisdiction is a jurisdiction only found in statute, so in this case, the court's jurisdiction to review and make any orders on the committal order which was made below is only found within section 13(3) of the 1960 Act, then what the court is essentially deprived of, the appellant is deprived of his rights in my submission under 54(4) of the Access to Justice Act 1999.
So abuse can only be a bar to the exercise of an inherent jurisdiction. It can't be a bar to the exercise of any statutory jurisdiction. Is that your submission?
My Lord, the question was posed by the court in the case of Re Norway's application. It's cited in paragraph 5 of my skeleton argument, which in my submission, has likeness to this case with the court being asked to exercise statutory jurisdiction. My Lord, it's a significant judgment which can be found in the authorities, if I may. My Lord, in that case, and the point of issue stop was not taken to the House of Lords in that case. It's at page tab 11 of the updated authorities bundle.
Can you give us a page? I don't have tabs.
314 onwards. 315 sets out the background to the appeal in the head note for the case. This was a case where the court was asked to grant an application pursuant to a statutory discretion and jurisdiction that can only be found within Section 1 of the Evidence Proceedings of the Jurisdictions Act 1975. The court refused in the first set of proceedings between the same parties to exercise that jurisdiction and made findings both of fact and of law as part of those proceedings. Similarly, the issue, it's page 315,
Yep.
Page 723 of the judgment. On the first appeal, the Court of Appeal held, amongst other things, that the proceedings in the City Court were civil proceedings of both Norwegian and English law, even though they concern fiscal matters, and therefore proceedings in any civil or commercial matter for the purposes of the Act, but by majority. So the court found it had jurisdiction to entertain the application, but on the facts dismissed the application.
Yep. The earlier court. Sorry, go on.
A second application was then made.
Yep.
In that case, and the issue, the discrete issue with which this court is concerned, the argument in the cross appeal was that because we are the same parties to the same proceedings with the same issues, the court, 2 points were taken. Either one, the court was bound by precedent from the previous decision of the Court of Appeal, and in the alternative on the cross appeal, there was an issue of stopper which prevented the court from exercising the jurisdiction.
The argument set out at page 333, isn't it?
Yeah.
My Lord, it is.
In the second paragraph.
Yes.
Yeah.
Contended that the witnesses were stopped from contending that the previous decision was wrong.
My Lord, the question that was posed on the cross appeal can be found at page 330 of the authorities, but at the very top of the page.
Yes.
Is whether the first decision of the Court of Appeal between the same parties, first of all, creates any precedent,
Yep.
meaning that the court was bound to find that it had jurisdiction, or whether any issue of estoppel was binding and prevented the court of exercising that jurisdiction, or indeed the witnesses of asking the court not to exercise the jurisdiction.
Well, that's the critical point. There were two separate questions that might arise. One is whether there was an issue of estoppel,
Yes.
which would prevent the witnesses taking the point, which I think the court said not. So that was the end of it. But the additional point we see in line 4 is, even if there would be an issue of estoppel so far as the witnesses were concerned, does that deprive the court of a jurisdiction which it would otherwise possess under the statute, or conversely, was it determinative of whether the court
Yes.
had jurisdiction or not?
Yes.
And as I understand what Lord Justice May said obiter on jurisdiction, it was obiter because there wasn't an issue of estoppel anyway, was that just because the witnesses might be issue estopped, that doesn't answer the question for the court, because it's for the court to decide its own jurisdiction, and we, the court, think in this case, so the Court of Appeal found, overturned on appeal, they didn't have jurisdiction. Is that a fair summary?
My Lord, it is
what,
the
what
question.
was decided?
My Lord, it was overturned on appeal on a different point. The issue of estoppel point was not taken on appeal.
No, but the jurisdiction point was
My Lord, yes.
was the subject matter of the appeal,
Yes.
and the House of Lords held that there was jurisdiction.
My Lord, the analogy which I draw from that case, which is at page 337 of the authorities bundle, and it's the paragraph below the page reference 744.
Yes.
The court found the court was not bound by the issue of precedent of the previous Court of Appeal decision, but went on to say it's unnecessary for the court to express any decided view on the question of whether the court can be deprived by the operation of principle of issue estoppel of a jurisdiction it would otherwise possess under the statute. It can only be found within the statute, this discretion. And because the argument had been fully dealt with before the court answered that question in the negative. And my Lord, the analogy which I draw on this appeal is the court has a jurisdiction confined on a contempt order to section 13.3 of the Administrative Justice Act 1960. The court has previously exercised its jurisdiction insofar as Lord Justice Mayles has found that the caveat of requiring permission is not made out, and whether this court then cannot re-exercise that jurisdiction by this full appeal.
Can I ask you two things about this case? First of all, this wasn't concerned with abuse, was it? It was concerned with issue estoppel.
My Lord, it was, but issue estoppel, of course, is a form of abuse. It was a collateral attack upon the previous.
It's a form of abuse,
yes.
But it's not determinative of abuse. You can have abuse even where there's no issue estoppel.
Yes.
And secondly, the dispute in this case, which either did or didn't give rise to an issue estoppel, was itself a jurisdictional dispute. That is to say, whether the Norwegian proceedings were in a civil or commercial matter.
Yes.
So that what Lord Justice May was saying is, where you have a dispute which is a jurisdictional dispute, it's not a question of issue estoppel for the parties to be determined of that. The court's got to look at it itself. We're not concerned, are we, in Lord Justice Mayles' decision, with a jurisdictional question. He wasn't deciding whether there was or wasn't a right under Section 13. He was simply dealing with a permission application, which I think you've accepted was the proper way of dealing with the matter in front of him.
But
the abuse which potentially arises in this case is not because there was a jurisdictional question which has already been decided, but because there was a substantive decision on the underlying merits of what you seek to argue on appeal.
My Lord, the Norway's decision, the issue estoppel arose from there was the point of law is whether the court had jurisdiction, and the secondary point was whether the facts, because of course the court found in the first set of proceedings that the court had jurisdiction, but that the application should not be entertained. In this case,
no, but there was the issue estoppel point didn't arise in relation to the second, because what happened first time round was the court said, we've got jurisdiction because it is a civil and commercial matter, but the questions are too broad. Go away and start again, and they did. And they came back and said, the Norwegian court said, one, we're saying it's a civil and commercial matter, and two, here are a lot of further more detailed questions. So the issue estoppel point, it arose as a matter of issue estoppel because a finding of Norwegian law is a finding of fact. But it was a finding of fact which was a jurisdictional question.
My Lord, the issue on this appeal, the basis on which this appeal is made, is one confined to the court's statutory discretion under Section 13.3 of the Administrative Justice Act 1960.
It's not.
My Lady,
That may be the basis on which you appeal, but the issue isn't the jurisdiction to appeal. The issue is the merits of the underlying contempt finding.
My Lady, Lord Justice Mayles, on the first appeal, found on the papers with the caveat of 5213 that permission should not be granted.
Yes.
The question for this court is whether that then deprives this court of still entertaining its jurisdiction or considering its jurisdiction.
It's not about
towards the
depriving jurisdiction, it's just saying is it abusive or not. It's something different. The effect may be that the claim can't proceed, but that's not to say that jurisdiction is being denied.
My lady, as part of the court considering in the round the facts of this particular case, one of the factors I invite the court to consider is whether the, which is acknowledged by the authorities, whether the appellant's full rights of appeal, which arose following the 17th of March order, are extinguished by the early decision of the court to refuse permission. That is essentially the heart of the issue of abuse.
Can I put it in this way to you? In the State of Norway case, the expression jurisdiction was being used in the sense of, does the court have power to grant the relief which is being given? In this case, when you talk about the jurisdiction in section 13, you're not talking about being deprived of the court being deprived of the power to hear the appeal. We're talking about whether the court is choosing not to exercise that power because of the previous conduct which would make it abusive. So you're not using jurisdiction in the same sense as it was being used in the State of Norway.
My lord, yes, the rights under the power which the court under the 1960 Act, section 13, also, of course, read alongside the rights of the appellant under the jurisdictional right of the appellant under section 54 of the Access to Justice Act. The right of appeal under section 54(2), because as of the 17th of March, this case became a criminal causal matter. The caveat of permission no longer existed, and that's the issue in my submission that the court can and should take in when it considers the rounds of whether the court should entertain this appeal.
But if we were to be against you on abuse, we would not be saying that the jurisdiction under section 13 doesn't exist. In the State of Norway case, that was the necessary consequence of it being or not being a civil and commercial matter. But in this case, if the court were to say, because of what happened before Lord Justice Males, you can't now proceed with the substantive appeal, that would not be the court saying, we have no jurisdiction under section 13. It would be, as in almost all other abuse cases, we do have jurisdiction, but it would be wrong to exercise it because it is abusive to pursue it.
My lord, the effect of that decision would be twofold. So far as this appellant's concerned, it would have the effect of the court finding that the appellant's statutory right, which arose from the 17th of March, was extinguished. So it would be the effect of the court saying...
No, not...
Just saying the practical effect is it just can't go on. The rights and the jurisdiction and all, they're there. It's abusive to allow the proceedings to go further. I mean, there's one point, I think we need to be a little bit careful in relation to the broad merits approach and taking things in the round, because actually Stewart and Goldberg, which I don't think is in the bundle, is authority, I think, for the proposition that is simply a broad merits-based approach to the question of whether or not the claimant in that sort of case should have brought their claim as part of the earlier proceedings. It's not saying that there's a broad merits-based approach more widely.
My lady, I adopt what...
Is that fair?
My lady, it is. I adopt what my lord said a moment ago, which is the scope of abuse is not necessarily confined to the factors in each case. And in my submission, the key factors in this case, which point against the court finding an abuse and upholding an abuse to prevent the full appeal being heard, which would have that effect, are set out in my supplemental submissions.
I see.
One,
right. I mean, I think we agree that what my lord may have been saying is, it's just that the categories of abuse are not closed.
yes,
That you accept.
Yes.
I mean, this may be one of those cases where actually the Barker example fits, which is use of the process for a purpose or in a way significantly different from its ordinary and proper use.
but the other effect of the judgment in my submission, if the full appeal is not heard, is those cases were, and the court has warned against this for obvious reasons, claims and applications are heard together. It does put the would-be appellant in the very difficult situation. So what if, presupposing the appellant in this case made the application to extend time until a date after the sentencing hearing, the judge refused within the case management discretion to do so, the would-be appellant is then faced with an appeal against the case management decision.
I understand that. I'm struggling at the moment to see how these matters have anything to do with the question of abuse. They may have something to do with whether or not the proceedings should be struck out or stayed or in some way allowed to proceed. But how can these matters go to whether or not the proceedings are abusive?
Melody, the two questions I posed to the court earlier, which is one, is it materially unjust to the other parties, the proceedings? In my submission, the answer to that has to be...
No, we've covered that. We're not,
yes.
not so interested
The
in
second, which the court rightly identified, is whether the administration of justice can be brought into disrepute by the court, now hearing the appeal, notwithstanding the order of Lord Justice Mayles. And it's the tension between the court quite rightly identifying, well, there is potential for any decision on the substantive appeal, if it's granted, for example, affecting Lord Justice Mayles' decision. That tension must be weighed, in my submission, also in terms of the administration of justice, of would-be appellants in committal proceedings. In the unusual circumstance of this particular case, which is there is a claim and a committal application side by side, and the appellant wishes to exercise the rights which the appellant has on the claim to seek permission, then in each and every case of that kind the appeal is not heard. There is a risk of there being a denial of access to justice, because if that right only arises on a later occasion, as it did in this case, then the appellant is put in the unenviable position which this appellant was in. I mean, it does, in my submission, it's inextricably linked to ground 3 of the substantive appeal. I stand here making arguments quite rightly identified by the court, which were not identified until the court raised the directions on Friday afternoon. The abuse point. The abuse point in this case arises on the back of the fact that there is a procedural unfairness in my submission by the fact that the claim and the application were heard together. The appellant's appeal rights from the moment both two were heard together were going to be affected.
That's not right. I mean, the same point potentially arose in the business mortgage case. The point arises because there was a contempt finding that was separate from the sanction finding. Your appeal as of right is against the committal order. This point will arise in any case, nothing to do with the claim and the application being dealt with together. It's that separation in time between the finding of contempt, in respect of which, if you wanted to appeal at that point, you need permission, and the sanction finding, the committal order, which you have an appeal as of right against. Those are the rules.
Melody,
you agree with that?
Melody, I do, but the fact in this case, which is different from the Hussein case, coming back to the claim, the material difference, it's not only does the would-be appellant have to persuade the court for an extension of time on the committal appeal, but also on the underlying claim. Now, the factors on the underlying claim, naturally a court may be reluctant, depending on the relief grants on the underlying claim, to allow an extension of time.
I think, speaking for myself, it's inconceivable, had submissions been made to His Honour Judge Davies, that if time was not extended till 21 days after sanction, there was a real possibility that you would be procedurally prejudiced in relation to your appeal against the claim and the appeal against the contempt findings, that he would not have granted that extension.
Milady, what in those cases where there is a claim and a committal application, there is an appeal, but the time in this case was fairly significant. It was between circa 2 months between January and March 21.
That's pretty standard in my experience.
Milady, what in those cases where the indulgence which is sought from the court by the would-be appellant is much further down the line, for example, because of preparation of a medical report.
But extension is a matter of principle.
Yeah.
The principle wouldn't be altered by the specific period of delay. It wouldn't be that sort of extension. It will be an extension because of legal, well, as a matter of principle.
My lady, the one distinguishing feature in my submission which is key, which remains the fact there was the need to apply for an extension potentially on both. And it would have been also open to the court, for example, to say, I'll grant an extension on the application for permission to appeal the committal order or the committal finding. But the claim, given the nature of the relief, that needs to be dealt with. That cannot go off into the long rest, must be dealt with now. And then the claim attacks the same findings, which this appeal in the claim did. I then come on my appeal on the application, and the court says, well, that is abusive because you've tried to attack those same findings.
His Honour Judge Davies recognised the significant overlap in the claim and the application. That's why he dealt with them together, rightly or wrongly, and whether there was objection or no objection to that. It is, in my view, speaking for myself, inconceivable that had you said there will be procedural difficulties if you force me to go ahead with an appeal on the application and the claim now, that he would have said, well, you've got to go ahead on the claim, but you can have an extension of time on the application. He recognised the overlap. I think this isn't getting us in. It's speculation, and I can't see where it's getting you.
It is, but it's certainly one factor that the court, in my submission, should not ignore.
Right. Okay. It's a factor we shouldn't ignore.
The application.
The possibility that a judge would have ignored the overlap and said, you've got to go ahead with your appeal against the claim. That's what we shouldn't ignore.
Yes.
Okay. Got that. Next.
I'm conscious that you've had a barrage of
Yes, you've done very well.
barrage of questions. But can I just, for my own benefit, try and sort of draw together the threads of your argument to see if I've understood essentially the points that you're making. First, that questions of abuse are fact sensitive, and therefore we need to look carefully at the facts of this case, see Hunter and various other cases. Secondly, that what's significant about the facts of this case are the following. A, the procedural position you found yourself in early February, having only an extension of time until the 10th of February, which meant you had to launch an appeal at that stage, and it had to be launched in relation to the claim as well, because of the problems of the overlap between the claim and the contempt finding. B, that your absolute right to appeal without leave only arose on the 27th of March, and that jurisdiction can't be removed by anything that's gone before, relying on State of Norway and the other cases. C, that the position is not the same before us on the substantive questions as it was before Lord Justice Mayles, because there's the additional evidence point addressed at paragraph 17 of the 27th of March judgment, and because of the procedural unfairness aspect which that engages, and lastly, as I understand it, because of the decision in business mortgages putting a focus on the importance of the question of law as to whether one can dispense retrospectively with personal service, which is your first ground of appeal. Now, that's my summary. It's certainly not yours, and it's not done justice to the detail in which you've developed those arguments. But have I identified the main points, or is there another one I should have on board?
Yes, you have, and there is a second point which flows on that the paper petition by Lord Justice Mayles, of course, not only finds that the court could have exercised the jurisdiction to retrospectively dispense with service, but would undoubtedly have done so. In my submission,
Sorry?
the court finds that the court would undoubtedly have
Yes.
exercised that jurisdiction if, of course, it was available. In my submission, there was no evidence before the court, absent an application, to retrospectively dispense with the court to make that determination.
Hang on, what are you doing? Criticising the decision of Lord Justice Mayers
Well,
on this?
Lady, unless the point is, unless until an application was in fact made to dispense, we find ourselves in a difficult position where whether the court could or would have been an answer for the lower court.
What's this got to do with the arguments before us?
Well, my lady,
You're saying you're criticising Lord Justice Mayers' thinking?
my lady, no, what the appellant says is, as part of the absolute right that the appellant has, if the full appeal was heard, the necessary effect of any full appeal would be on appeal if the court, it is common ground on the facts before the court that personal service had not been affected at the time of this breach. It's right to say that the rules are clear, that the injunction subject only to
No, so
application.
what's your point? What are you saying?
Lady, the appellant has not had the right to have such an application dealt with to dispense with service.
But he didn't even raise the point. I mean, leaving aside my lady's point, he proceeded on the basis that he had full knowledge of the injunction and what he was allowed and not allowed to do, and he complied with the provisions of the order. He didn't take this point until appeal.
My lady.
So how could he have had an application to dispense with service dealt with?
My lady, the difficulty which the appellant finds himself in is that the appellant below was conducting the litigation as a litigant in person. I accept.
No, he had counsel at the hearing.
My lady, the reality from the judgment is, for all intents and purposes, the committal is somewhat of a side. There are substantive proceedings alongside the committal, and it's right to say that alongside counsel for the appellant not identifying the want of service at the time of the allegation, the court and the respondent are not alive to it. It's an inescapable fact in my submission.
The respondent was alive to it and said in her witness statement that service was effected on, I think, the 5th of January.
5th of February, my lady.
Sorry, I beg your pardon. So the point was there. She said he was present at the hearing on the 27th of November when the injunction order was made, and that he complied with paragraphs in the injunction order and knew what it said, although it was actually served on him later. And he took no issue with that, apparently, and didn't address that in his evidence. But that's a side issue.
My lady, it is.
How is it, as my lady has asked you, relevant as an additional point to the points my lord has put to you, that we should take into account when we determine whether this application is now an abuse?
My lady, the point identified by my lord in summarising the appellant's case on the abuse point, one of the points is that it would deprive the appellant of his statutory rights. As part of those statutory rights, alongside the right to appeal without permission, is the right of the injunction to be personally served prior to any application for committal being made.
Right, anyway, it's somewhere along my lord's second point, as far as it's something to do with that sort of idea.
Okay.
But if you mind my back for a moment.
Yes.
Yeah, absolutely.
My lord, from the checklist the court provided a moment ago, there are the issues set out insofar as the prejudice is concerned, which I've not addressed the court, and which I invite the court to note to page 6,
Yep.
subparagraph C. The court has the point at subparagraph D,
Well, hold on. C is irrelevant, isn't it? We're concerned with the effect on the administration of justice, not on whether a respondent would suffer prejudice.
I mean, they have suffered some prejudice because
Yeah.
they had to respond to the February application. They did.
My Lord, it's the second part of that submission as part of the court considering the administration of justice.
Stigma.
Yes.
Ah, okay.
I.e. what is at stake for the appellant in this case if the full appeal is not heard. My lady, in respect of that particular point, I identified in the Masri case this morning the points which the court will note so far as these are, by definition, exceptional proceedings insofar as they concern the liberty of the appellant, and that's a factor I invite the court to take into account.
Yep.
The
Okay.
appellant's fallback position is set out at page 7. I've dealt with the Roman numeral 4. At paragraph 9, I deal with the court's jurisdiction to this extent. In my submission, if the only way of giving effect to the appellant's absolute right is by, rather than the court making a decision which potentially would conflict with that of Lord Justice Mayles on the papers, would be to consider reopening that decision, in which case the bringing the administration just in disrepute point, the point can be met by the court exercising that power, and I readily accept, and I know my lady turns the point immediately, the jurisdiction under 5230 of the rules is extremely rare and confined.
Yep.
And what a would-be applicant needs to satisfy the court of is a high threshold.
Yep.
And speaking to the three limbs of that test.
Yep.
So you're not pursuing 317?
My lady, I suspect my submissions on the exceptionality, there is no, as I see it within the rules, on 317, a final order. It would be effectively the same question, same factors.
Yeah.
All right, so speaking to the three limbs of the highly restrictive test in 52.31.
Lady, yes, if I may just...
Why is it necessary to avoid real injustice?
The real injustice in this case is the appellant not having the absolute right to appeal being met. It has been caveated by a refusal of permission, which, and it's that refusal of permission which can and should be reopened. The risk of injustice is not having the points met, grounds 1, 2 and 3 considered at a full appeal.
Yep, okay.
And the circumstance of this case, in my submission, are exceptional by the very nature. The right of an appellant in committal proceedings, the absolute right, is seen as an exceptional exception to the rule for permission. And in this particular case, the circumstances are particularly peculiar by the fact, as the court has identified in the authorities I deal with in the substantive appeal, the hearing of a claim, a substantive claim, and a committal application together. There should be caution exercised. That caution was not exercised in this case, and flows through to not only the first judgment, but as reflected by paragraph 17 of the second judgment. If the court does not hear the full appeal, in this case, the second judgment, which is spoken in respect of ground 3, and the court's findings to the effect that the appellant brought this upon himself for failing to provide disclosure when disclosure is required. In the context of the committal application, where bluntly there is no obligation to provide documents, but likewise any respondent to a committal application has an absolute right not only to remain silent should he or she so wish, but also to rely upon such evidence as he or she so wishes at trial. I mean, there is no other remedy in this case. The only way of the appellant...
So, actually, having the things rolled up together could and should have worked to his advantage, because he would have been entitled to say, so far as the committal application is concerned, I can adduce all the evidence I want.
Because the debarring order didn't bite on...
Didn't bite on the committal
application.
So that perhaps if his advisors had been alive to that, a rolled-up hearing would have been to his advantage rather than disadvantage.
My Lord, the relevant order which I speak to is at page 18 of the supplemental bundle.
That affected the claim, his defence of the claim.
My Lady, and also the committal application. My Lady, this is the order which in my submission lies at the heart of the case.
Sorry, just give me the page reference.
Page 18, my Lord.
18?
18, 1-8, the supplemental bundle. Well, perhaps it should be read in context between the order on the previous page to give the context of the order which followed. Page 16. An application was made in Form N244. The application was twofold. One, to strike out the defence for failing to comply with various directions for disclosure and the like. And secondly, for a committal application. For a committal order to be made. I just pause there for a minute. I don't wish to trespass too far into the substantive appeal, but as part of the N244 application, the particular breach found by the judge at trial was not identified on a schedule with particulars.
But the debarring order at page 18, in relation to evidence, does not bind the committal application. It's in the trial. Trial be listed.
Yes, and the trial was hearing both matters together.
Yes, but there's nothing to... the defendant was not constrained in any way in terms of the evidence he could serve in response to the committal application.
My Lady, in my respectful submission, that's not the case.
Right.
But what about paragraph 3? The defendants may rely on the evidence served in response to the committal application.
Yes, by that stage it had already been served, so he was limited to relying upon that which had already been served.
No, where does it say that?
Lady, by the language used, the defendants may, however, rely on the evidence served in response to the committal application. Yes. The evidence at that stage already been served.
Yeah.
But where does it say if he comes along with other evidence in relation to the committal application, he's not allowed to rely on it?
Well, my Lady, the trial was of both matters. So
yes, but
paragraph 3 is to be read alongside the order which listed the matter for trial.
But there are two separate things. There's the trial and there's the committal application. They're separate. They may have been heard at the same time.
And that's made clear by paragraph 4. My lady's point is emphasised because it says the trial will be listed together with the committal application. So evidence in relation to the committal application is fine, but he is debarred from relying on evidence in the trial because of his failures.
My Lady, the first bit to note in respect to this order, this hearing was listed solely in respect of the strikeout application. then the committal application matters were dealt with at the hearing,
Yes.
essentially without notice.
Where does it say he's debarred from relying on any further evidence in the committal application?
Melody, the interpretation of the appellant of this document, in my submission, would be a reasonable interpretation of...
But that's an extraordinary thing to say, so that the debarring order was because of failures to comply with directions in the trial, not the committal application.
There is no other direction within that order.
But there was no basis to debar the defendant from relying on any evidence in the committal application on the basis of a failure to comply with earlier directions, because there hadn't been any, had there?
Well, there had, my lady,
Yes, no breach of them.
My lady, the directions on the committal can be found on page 16.
And he'd failed to comply with those, had he?
My lady, he had not, at the first hearing of the application, which was a joint application, the court, rightly in my submission, directed that the two should be split and heard separately. We have the strikeout application, which is in respect to the claim.
But did he breach the directions at 7 and 8?
My lady, he did not.
No. So the breaches were in relation to the directions on the claim allocated to the multi-track.
Yes.
Yeah.
My lady, and then if one goes to page 18 and reads the order in my submission as a whole, the defendant's not writing up any documents at trial, but reason they're failed to comply with the orders for disclosure and exchange. Defendants may, however, rely on the evidence served in response to the committal application. At that stage, we are at this stage at the end of September, so the directions are being complied with, evidence are being served. The position that in my submission that naturally puts, because then once the claim is consolidated with the application...
No, there wasn't a consolidation order, ever.
Well, they were listed...
No, that's very different to consolidation.
Milady, they were listed to be heard at the same time.
Correct.
Yes.
So the difficulty, naturally, the appellant would have is attending the final hearing at which both applications were heard together.
Well, that's what I'm putting to you. I'm not understanding why that's the difficulty so far as the committal application is concerned. He's page 16. He's told to put in all the evidence he wants to on the committal application by the 15th September. He's apparently done so. And page 18, it's made clear that he's entitled to rely on that in response to the committal application. If the effect of having the two heard together was as a result of an overlap between evidence relevant to the claim and evidence relevant to the committal application, that didn't deprive him of the opportunity to rely on whatever evidence he wanted to in relation to the committal application. It actually afforded him to get into the judge's mind on the claim evidence that he might not otherwise have been entitled to because of the overlap.
My lord, the key evidence which was available to the judge at the sentencing hearing when further directions were given for sentencing was the evidence from the third-party MailChimp as to whether or not...
But Mr Nambiar hadn't even got that evidence by the time of the contempt hearing.
My lady, yes, and Mr Nambiar's position on that is that because of the effect of this order, the view he reasonably took was that he was unable to rely upon those documents.
Well, you say he reasonably took it. Looking at it, we can't see that that's, speaking for myself, that is a reasonable reading of it.
Lady, given that both are being heard at the same time, so if the appellant attended trial, for example, with evidence from MailChimp, given the fact that at that point the defendant had already provided evidence in response to the committal application, but was debarred from any evidence on the trial, the difficulty the appellant faced was attending trial with evidence on the committal, but was then debarred from on the claim.
Why was it a difficulty? My lord's put to you. He was, in a sense, advantaged.
My lady, the interpretation taken by the appellant is that that had the effect of preventing him from relying upon the
Well, let's say for the moment he's wrong about that. He was able to he's wrong about his interpretation. On an objective view, of this order, he was able to rely on the evidence in the committal application, even if he couldn't rely on it in the trial.
Well, maybe the evidence in the committal application at that point in time already been filed and served.
Well, he might have had to ask the court for permission, just as you have to put in a supplemental skeleton argument. He might have had to ask the court for permission to put in additional evidence on the committal application. But he wasn't debarred.
Could you just remind me where his evidence is as to his understanding of the order, as you suggest? I'm looking at his fifth statement. I can't find it there. Is it in his fourth?
Well, it's not addressed in the witness evidence.
Right.
And what about paragraph 10 of the judge's 17th March judgment?
Because he was very aware of
It's not
avoiding
suggested
prejudice.
by Mr. Nambiar that he couldn't have produced this evidence at the trial.
My Lord, alongside that finding, the court does identify within the judgment paragraph 39 of the judgment, page 61. My Lord, I should caveat this with I accept, in terms of the context, we don't have the transcript of the proceedings below. The judge summarised the complaints. Whilst Mr. Nambiar continually protested that the trial was unfair because the claimant does not produce documents, I bear in mind the defendant never asked for specific disclosure. Of course, the defendant was a litigant in person, and any limited non-disclosure by the claimant must be set against the defendant's repeated failure to provide any disclosure. Mr. Nambiar was able to produce individual documents during the course of trial. That serves to show in my submission that the appellant was raising issue with the unfairness, and that goes to show in my submission the fact the appellant was of the mind that I'm not permitted to rely upon documents, and then at trial was producing documents. One of the key factors in the court's decision as to why the finding was made was the want of evidence from MailChimp.
I'm just not understanding it. It looks to me from 39C as though Mr. Nambiar was allowed to produce documents insofar as he had additional documents he wanted to rely on at the trial itself. I don't see how that is consistent with him having taken the view that he was debarred from producing any further material.
My Lord,
at the hearing, whether in relation to the trial itself, but certainly in relation to the committal application.
My Lord, following the hearing, the directions hearing, the only other round of evidence catered for by the court was in respect of, it's dealt with paragraph, page 18 of the supplemental bundle.
Well, just deal with my Lord's point, 39C. How do you read 39C? Mr. Nambiar was able to produce individual documents during the course of the trial.
Yes. Yes. What
Right.
Mr. Nambiar...
So that is inconsistent with believing himself to be debarred from producing evidence to rebut the contempt allegations. Do you accept that?
Milady...
Do you accept that?
In part, Milady, yes.
Right.
But what it's not inconsistent with is a party who believed he couldn't rely upon any further witness evidence in support of the committal. The judge's finding, there was evidence produced from MailChimp at trial. The criticism of the trial judge was the evidence was not in, essentially, statement form from MailChimp, i.e. there was no such evidence from a witness statement from MailChimp saying we were in control of emails sent on behalf of this defendant, and no such emails were sent.
Yes.
And what the appellant contends is the effect of hearing both matters together and the court debarring on one, granting permission, which he says was limited to the evidence already served, the witness evidence already served on the other, had the effect of prejudicing his trial rights.
Now, I'm sorry to press you on paragraph 10 of the 27th of March judgment, which is at page 79. But the judge there records that it wasn't suggested to him on that occasion, on behalf of Mr. Nambiar, that he couldn't have adduced the new evidence at the trial. Your submission to us is he believed that he couldn't.
My lord, the trial at that stage had been and gone. That was, insofar as the appellant was concerned, a matter for the appellate court in light of the previous case management decisions that had already been made, consolidating the proceedings.
So I'm
Well,
not understanding your...
my lord, had
the point I'm putting to you is, what was said to the judge on the 27th of March is, I accept that this new evidence is evidence that I could have produced at trial. What you're submitting to us, which, as it seems to me, is inconsistent, is that it wasn't adduced at trial, and he believed that it couldn't have been adduced at trial because of the debarring order. Now, I don't at the moment see how those two can be advanced consistently with each other, but it's my fault. That's what I need help on.
My lord, it's the interpretation of the order which the representative of the appellant take from the order that was made in December, which...
Well, then why didn't he say that in response to the judge? Why didn't he say, but I was debarred? I couldn't have adduced this evidence. I was debarred. Why doesn't it record that at paragraph 10?
Well, so far as the trial is concerned, before we get to...
But my lord's point is about the second hearing in March and paragraph 10. Can you answer that, please?
At that stage, the trial had been and gone. It was a matter the appellant deemed that was more a matter for the court on appeal as opposed to the trial judge, because the trial had gone, findings had been made, the claim and application had been heard as one.
I don't think that answers my lord's question. Do you want to have one more go?
My lady, the crucial point is whether, had the issue been raised by Mr. Nambiar below to complain, well, I was debarred, and that's why you have this evidence now. That would only serve, given this was a sentencing hearing, that would only serve in my submission, or would serve no purpose at all in the proceedings below. The trial had been and gone.
I think I may have diverted you onto this, which is really a point which goes to the substance of your arguments, if you're allowed, rather than abuse. And it's my fault for suggesting that actually you may have been advantaged by the hearings being heard together rather than otherwise.
Well, perhaps it went to your point that there's no other remedy. But anyway, yes.
My lady, unless I can assist the court any further at this stage.
What about the dealing with the fact that you did not provide the court with the details of this application for permission to appeal in relation to the claim and the application, or with copies of those documents or the order made by Lord Justice Males, when perhaps you ought to have done, so that this point only, this court was only alerted to the point very late in the day. Do you want to say anything about that?
I addressed the court at paragraph 10.
Yeah.
The question was posed to counsel for the appellant, and being counsel comes out, I answered at paragraph 10, onwards of the supplemental second argument. My lady, I start by offering an apology to the court. The simple point is it was a can of worms, as it were, that simply the appellant was not alive to when this appeal was issued. The forefront of the appellant's mind, as I addressed the court on in dealing with the abuse point this morning, is the absolute right to appeal, which is reflected by paragraph 4 of the order of the judge below. But it was certainly not a case where the appellant thought, well, if no mention is made, then the court won't be alive to the fact that a judge of this court has considered the point I did raise in my second argument. I readily accepted and deal with the substance, the fact that both the claim and application had been the subject of an appeal.
You did.
I simply did not appreciate. I should have perhaps maybe a little consolation. The respondent at the time, and certainly the court below at the time, didn't appreciate this potential, given the peculiar circumstances.
Well, there's no reason why the respondent should. Why do you blame the respondent?
Lady, I don't. I perhaps raised what the respondents did not.
But why would they?
As a foundation for the.
Why would they?
The failure of the appellant was a reasonable one. Ordinarily, if an appellant respondent feels that the appeal is abusive, the respondent had the opportunity or the liberty to apply to strike out. I simply make the point, up until March of this year, we understood the appellant being represented. That ties in with the second explanation, which is why the respondent's statement pursues the practice direction was not addressed in my opinion, bluntly, until last week. I understood that the respondent would be responding in the usual way to this appeal. It was only on the 12th of July, when I was compiling the authorities, that I was made aware that, say for this court, the respondent would not be formally opposing the appeal. Had I known in advance, then I would have preempted the points which I've sought to preempt today. So I do offer my apologies to the court.
Sorry, had you known in advance that they were in voluntary liquidation and wouldn't be opposing the appeal, what would you have done? What would it have preempted?
My lady, it perhaps would have preempted the need to add further argument in a supplemental skeleton argument.
So you were waiting for the respondents to raise these points, were you?
My lady, yeah, I assumed that the point I'd be addressing the court on my feet in the appeal in the usual way and responding in my right of reply would be the simple point. I didn't appreciate that the respondent was not a party who'd not formally responded to the appeal.
I may have missed this detail, but was the judgment of Lord Justice Mayles put before the judge at the sentencing hearing? When did you receive it?
Lady, you mind me back for a moment?
Yes.
Lady, I simply don't know the answer to the question. What I am instructed is that in accordance with the practice direction, the Appellants Notice, which was issued, I believe, on the 10th or 11th of February, was lodged both at this court and also the court below.
That asserted that you didn't need permission to appeal, so I expect the judge would have assumed that nothing had happened in relation to that.
My lord, the asserted either permission was not needed, and then asserted the alternative insofar as permission was required and sought to address the court, or my permission should have been given.
I've missed that.
It was in the skeleton argument.
No, I'm looking at the notice of appeal.
Ah.
Do you need permission to appeal?
No.
No, just the box that's been ticked.
My lord, the appellant, in accordance with the instruction I gave to the court, which I readily accept on the authorities, as to whether where a court gives an indication that a sentence was inevitable. I think I addressed that in my skeleton argument.
Actually, to be fair to you, it's perhaps a little more ambivalent, because there's a box that says, do you need permission to appeal, which has to have yes or no, and then there's another section which is obviously directed to whether you've ticked yes, which says, has permission to appeal been granted? And if the answer to that is no, then you fill in box B, and actually box B says the appellant's legal representatives seek permission to appeal. So perhaps it's not as clear cut as I thought. I was being unfair to you.
Highly unsatisfactory if the judge wasn't aware of what was going on at the sentencing hearing.
My lady, I simply, other than knowing that the appellant's notice had been lodged to the court below, I know not whether, from simple memory from it being so long ago, whether...
Well, it's not that long ago. You can't tell us that the order of the Court of Appeal was put before the judge.
I think no.
Is there anything else that you need to tell us today in discharge of your duty to the court in the absence of the other side being present?
My lady, no.
Does that complete your submissions, Mr. Lewis? I appreciate we've asked you a lot of questions, and you've dealt with them valiantly. Yes. Well, we will rise now a little earlier than usual, and we'll come back at 2 o'clock and at least tell you how we're going to proceed. Thank you.
Great, thank you.
Court rise.
Can I take the court be locked over lunch? Yeah.
About 10 to 2, we'll come back.
Can I leave my
Yes.
right.
Yes, in the last